Suspended Public Protector Advocate Busisiwe Mkhwebane wants the chairperson of the Section 194 inquiry into her fitness to hold office to recuse himself. Mkhwebane also wants DA MP Kevin Mileham to be removed from the committee. She claims the pair have been unfair against her. Let's speak now to Advocate Romeo Nthambeleni, who is a legal expert. Thank you so much for your time, Advocate Nthambeleni. Given what you've seen play out in the inquiry so far and some of the tensions that we've seen unfold, Advocate Busisiwe Mkhwebane's lawyers also in the beginning saying that she's participating under protest. Are you surprised that we are here now?
Good evening to you and the viewers. I'm actually not surprised with that background that you have said. It's very clear that that is where we are actually heading. And this issue of the recusal has been going on for quite a while now. Since the commencement of the Section 194 inquiry, we have had consistently an indication that an application is going to be brought for recusal of the chairperson and the other member that you've just mentioned, due to bias. So to answer you directly, yes, I'm not surprised about what is actually transpiring now.
The argument is that the committee has breached all three standards as prescribed by the rules of the National Assembly. They say these are fairness, reasonableness and/or transparency. What do you make of this particular argument? Can it stand the scrutiny?
Yeah, those rules that you have just referred to now are the rules of natural justice that gives each and every person who's appearing before any court or a tribunal an opportunity to ventilate their matter without fear, without favor, and without prejudice. And the test for recusal is high. We have seen with the cases that have gone to the Constitutional Court. The recent in mind is the matter of the former President Jacob Zuma and the Zondo Commission. And the test is a bit high. To make an allegation is very easy, but when you have to actually apply the test of recusal and cross each and every box, you find that it might actually be difficult to actually prove the recusal, especially of the chairperson in the case that we're actually dealing with. And in case of the case, the person that we've just referred to now, Kevin, there might be an issue of conflict of interest that might need to actually be proved because of the spousal relationship that he has, and with the person who has actually brought a complaint. So there might be some semblance of an argument that can be brought and sustained on that basis.
There also is another argument towards the chairperson as well around the issue of not granting the request to call ANC President Cyril Ramaphosa to appear before the inquiry. One of the things when you read the arguments that are laid out by the lawyers, they say that because he's an ANC president and the chair is a loyal member of the ANC, they are then not surprised that he got to the conclusion that the president, should not come and appear before the inquiry, that he must not be subpoenaed. Could a conflict arise given this argument that they are raising?
Look, it's an important consideration to actually make. But what is important in this matter is that decision he did not take alone. He took with the advice of the legal advisors at the in Parliament that were actually looking at the matter and looking at the relevance of the president in appearing in that committee. So that is important. You just don't call a witness for the sake of calling the witness. There must be a relevance of why that particular witness is being called and the evidence that witness might bring, and the cross-examination that witness might be subjected to. It must be relevant to the inquiry. So based on that and the advice that he got from the legal advisors, I think that the chairperson there has crossed his T's and dotted his I's, so that he will be sure that the decision that will be taken can stand the test of time, even if it is brought before the court, despite the issue of him being a member of the ANC. Because let's not forget that the work that is being done by Parliament is outside the ANC, and the Constitution requires that to be done without favor, without fear, and without prejudice. So you cannot marry the relationship between the work of the ANC and the allegiance to the ANC and the allegiance to the Constitution itself and the duty that is placed on the chairperson of the inquiry that he has to follow under the Constitution. So those are two different things altogether.
Advocate Nthambeleni, there's also another layer to this issue. Some have said that the composition of the committee itself is also flawed, talking about how these are some of the MPs that would have made statements in the public domain about the public protector in their work as leaders of various political parties in their own right. And some have said that then this should have been a challenge even from the beginning to say that they may not be impartial. I wonder, what do you make of that argument?
No, that argument does not hold any water whatsoever, because the members of that committee are supposed to do their work without fear and without prejudice. And if you want to start recusing everyone, then no one will have the authority to be able to sit on that committee, because one way or the other they could have made a statement, they could have made a comment. But then the most important question is the test that must be applied, whether when they were given the responsibility, they executed the responsibility without fear, without favor, and without prejudice. So if you want to exclude everyone, then no member will be fit to actually sit in that committee, because one way or the other, in terms of the work that they're actually doing, they're confronted with this type of matters, and they engage with those matters on different platforms altogether. So I think that does not hold any merit whatsoever in terms of the other members. But as we have given that, if you can link a member who has made a complaint and a spouse, then perhaps there you might be having an argument that can stand the test of time. But with other members, I don't think there's merit in that submission.
How do you foresee this one, play out in the public domain? Should they not get their way and the process is supposed to continue? How much of a complication or even an extended process do you foresee here?
Yeah, you're correct. It's going to drag out. If they don't get their way, obviously, with the chairperson refusing to recuse himself, I'm definitely sure that they're going to bring an application in court, and then that application should be entertained by the court to check if ever there's any merit in that particular recusal. Whether the court grants it or refuses it, then the processes of courts unfold up until the constitutional court. So we can never even put a timeline if that ball can be set rolling in motion, and then it goes outside the hands of Parliament. So it means that that parliamentary process will be kept on hold up until courts make the final decisions and make final call in relation to the subject matter.
All right, Advocate Nthambeleni, thank you so much for your insights this evening. Do appreciate them. That was Advocate Romeo Nthambeleni, a legal expert, as we look at the application now that has been brought for the Section 194 Committee Chair and MP Kevin Mileham to, recuse, in fact, the Chair to recuse himself and MP Mileham to then be removed from the Section 194 Committee. Let's then see how this matter then continues to play out in the public domain.